Citizens United v. Federal Election Commission, 558 U.S. 310, 2010, is a landmark U.S. constitutional law, campaign finance, and corporate law case dealing with regulation of political campaign spending by organizations. The United States Supreme Court held, 5-4, on January 21, 2010 that the Free Speech Clause of the First Amendment to the Constitution prohibits the government from restricting independent expenditures for communications by nonprofit corporations, for-profit corporations, labor unions, and other associations. In the case, the conservative nonprofit organization Citizens United sought to air a film critical of Hillary Clinton and to advertise the film during television broadcasts shortly before the 2008 Democratic primary election in which Clinton was running for U.S. president. Federal law, however, prohibited any corporation, or labor union, from making an electioneering communication, defined as a broadcast ad reaching over 50,000 people in the electorate within 30 days of a primary or 60 days of an election, or making any expenditure advocating the election or defeat of a candidate at any time. The court found that these provisions of the law conflicted with the U.S. Constitution. However, the court upheld requirements for public disclosure by sponsors of advertisements. The case did not affect the federal ban on direct contributions from corporations or unions to candidate campaigns or political parties. The decision was highly controversial when announced and remains a subject of much discussion. Case summary. In the case, No. 08-205, 558 U.S. 310, 2010, the conservative nonprofit organization Citizens United wanted to air a film critical of Hillary Clinton and to advertise the film during television broadcasts, which was a violation of the 2002 Bipartisan Campaign Reform Act, commonly known as the McCain-Feingold Act or BCRA, pronounced BCRA. Section 203 of BCRA defined an electioneering communication as a broadcast, cable, or satellite communication that mentioned a candidate within 60 days of a general election or 30 days of a primary, and prohibited such expenditures by corporations and unions. The United States District Court for the District of Columbia held that 203 of BCRA applied and prohibited Citizens United from advertising the film Hillary, the movie in broadcasts or paying to have it shown on television within 30 days of the 2008 Democratic primaries. The Supreme Court reversed this decision, striking down those provisions of BCRA that prohibited corporations, including nonprofit corporations, and unions from making independent expenditures for electioneering communications. The majority decision overruled Austin v. Michigan Chamber of Commerce, 1990, and partially overruled McConnell v. Federal Election Commission, 2003. The court, however, upheld requirements for public disclosure by sponsors of advertisements, BCRA 201 and 311. The case did not involve the federal ban on direct contributions from corporations or unions to candidate campaigns or political parties, which remain illegal in races for federal office. Background. Section 203 of the Bipartisan Campaign Reform Act of 2002, known as BCRA or McCain-Feingold Act, modified the Federal Election Campaign Act of 1971, 2 U.S.C. 441b to prohibit corporations and unions from using their general treasury to fund electioneering communications, broadcast advertisements mentioning a candidate in any context, within 30 days before a primary or 60 days before a general election. During the 2004 presidential campaign, a conservative nonprofit 501(c)(4) organization, Citizens United, filed a complaint before the Federal Election Commission, FEC, charging that advertisements for Michael Moore's film Fahrenheit 9/11, a docudrama critical of the Bush administration's response to the terrorist attacks on September 11, 2001, produced and marketed by a variety of corporate entities, constituted political advertising and thus could not be aired within the 30 days before a primary election or 60 days before a general election. The FEC dismissed the complaint after finding no evidence that broadcast advertisements featuring a candidate within the proscribed time limits had actually been made. The FEC later dismissed a second complaint which argued that the movie itself constituted illegal corporate spending advocating the election or defeat of a candidate, which was illegal under the Taft-Hartley Act of 1947 and the Federal Election Campaign Act amendments of 1974. In dismissing that complaint, the FEC found that the complainant alleged that the release and distribution of Fahrenheit 9/11 constituted an independent expenditure because the film expressly advocated the defeat of President Bush and that by being fully or partially responsible for the film's release, Michael Moore and other entities associated with the film made excessive and/or prohibited contributions to unidentified candidates. The Commission found no reason to believe the respondents violated the Act because the film, associated trailers, and website represented bona fide commercial activity, not contributions or expenditures as defined by the Federal Election Campaign Act. In response, Citizens United produced a documentary, called Celsius 41.11, highly critical of both Fahrenheit 9/11 and 2004 Democratic presidential nominee John Kerry. The FEC, however, held that showing the movie and advertisements for it would violate the Federal Election Campaign Act, because Citizens United was not a bona fide commercial filmmaker. In the wake of these decisions, Citizens United sought to establish itself as a bona fide commercial filmmaker before the 2008 elections, producing several documentary films between 2005 and 2007. By early 2008, it sought to run television commercials to promote its political documentary Hillary, the movie, and to air the movie on DirecTV. In the District Court. In December 2007, Citizens United filed a complaint in U.S. District Court for the District of Columbia challenging the constitutionality of several statutory provisions governing electioneering communications. It asked the court to declare that the prohibition corporate and union funding were facially unconstitutional, and also as applied to Hillary, the movie, and to enjoin the Federal Election Commission from enforcing its regulations. Citizens United also argued that the Commission's disclosure and disclaimer requirements were unconstitutional as applied to the movie pursuant to the Supreme Court decision in Federal Election Commission v. Wisconsin Right to Life Incorporated. It also sought to enjoin funding, disclosure and disclaimer requirements as applied to Citizens United's intended ads for the movie. In accordance with special rules in Section 403 of the BCRA, a three-judge court was convened to hear the case. On January 15, 2008, the court denied Citizens United's motion for a preliminary injunction, finding that the suit had little chance of success because the movie had no reasonable interpretation other than as an appeal to vote against Senator Clinton, that it was therefore express advocacy, not entitled to exemption from the ban on corporate funding of electioneering communications, and that television advertisements for the movie within 30 days of a primary violated the BCRA restrictions on electioneering communications. The court held that the Supreme Court in McConnell v. FEC, 2003, had found the disclosure requirements constitutional as to all electioneering communications, and Wisconsin RTL did not disturb this holding because the only issue of that case was whether speech that did not constitute the functional equivalent of express advocacy could be banned during the relevant pre-election period. On July 18, 2008, the District Court granted summary judgment to the Federal Election Commission. In accordance with the special rules in the BCRA, Citizens United appealed to the Supreme Court, which docketed the case on August 18, 2008 and granted certiorari on November 14, 2008. The Supreme Court heard oral argument on March 24, 2009 and then asked for further briefs on June 29. The re-argument was heard on September 9, 2009. Before the Supreme Court. During the original oral argument, Deputy Solicitor General Malcolm L. Stewart, representing the FEC, argued that under Austin v. Michigan Chamber of Commerce, the government would have the power to ban books if those books contained even one sentence expressly advocating the election or defeat of a candidate and were published or distributed by a corporation or labor union. In response to this line of questioning, Stewart further argued that under Austin the government could ban the digital distribution of political books over the Amazon Kindle or prevent a union from hiring an author to write a political book. According to a 2012 article in The New Yorker by Jeffrey Toobin, the court expected after oral argument to rule on the narrow question that had originally been presented: could Citizens United show the film? At the subsequent conference among the justices after oral argument, the vote was 5-4 in favor of Citizens United being allowed to show the film. The justices voted the same as they had in Federal Election Commission v. Wisconsin Right to Life Incorporated, a similar 2007 case, with Chief Justice Roberts and Justices Scalia, Kennedy, Thomas, and Alito in the majority. Chief Justice John Roberts wrote the initial opinion of the court, holding that the BCRA allowed the showing of the film. A draft concurring opinion by Justice Kennedy argued that the court could and should have gone much further. The other justices in the majority agree with Kennedy's reasoning, and convinced Roberts to reassign the writing and allow Kennedy's concurrence to become the majority opinion. On the other side, John Paul Stevens, the most senior justice in the minority, assigned the dissent to David Souter, who announced his retirement from the court while he was working on it. The final draft went beyond critiquing the majority. Toobin described it as some of the court's dirty laundry, writing that Souter's dissent accused Roberts of having manipulated court procedures to reach his desired result, an expansive decision that, Souter claimed, changed decades of election law and ruled on issues neither party to the litigation had presented. According to Toobin, Roberts agreed to withdraw the opinion and schedule the case for reargument. However, when he did, the questions presented to the parties were more expansive, touching on the issues Kennedy's opinion had identified. According to Toobin, the eventual result was therefore a foregone conclusion from that point on. Toobin's account has been criticized for drawing conclusions unsupported by the evidence in his article. On June 29, 2009, the last day of the term, the court issued an order directing the parties to re-argue the case on September 9 after briefing whether it might be necessary to overrule Austin and or McConnell v. Federal Election Commission to decide the case. Justice Stevens noted in his dissent that in its prior motion for summary judgment Citizens United had abandoned its facial challenge of BCRA 203's constitutionality, with the parties agreeing to the dismissal of the claim. Justice Sotomayor sat on the bench for the first time during the second round of oral arguments. This was the first case argued by then Solicitor General and future Supreme Court Justice Elena Kagan. Former Bush Solicitor General Ted Olson and First Amendment lawyer Floyd Abrams argued for Citizens United, and former Clinton Solicitor General Seth Waxman defended the statute on behalf of various supporters. Legal scholar Erwin Chemerinsky called it one of the most important First Amendment cases in years. Opinions of the court. Majority opinion. Justice Kennedy's majority opinion found that the BCRA 203 prohibition of all independent expenditures by corporations and unions violated the First Amendment's protection of free speech. The majority wrote, "If the First Amendment has any force, it prohibits Congress from fining or jailing citizens, or associations of citizens, for simply engaging in political speech." Justice Kennedy's opinion also noted that because the First Amendment does not distinguish between media and other corporations, the BCRA restrictions improperly allowed Congress to suppress political speech in newspapers, books, television, and blogs. The court overruled Austin, which had held that a state law that prohibited corporations from using Treasury money to support or oppose candidates in elections did not violate the First and 14th Amendments. The court also overruled that portion of McConnell that upheld BCRA's restriction of corporate spending on electioneering communications. The court's ruling effectively freed corporations and unions to spend money both on electioneering communications and to directly advocate for the election or defeat of candidates, although not to contribute directly to candidates or political parties. The majority ruled that the Freedom of the Press Clause of the First Amendment protects associations of individuals in addition to individual speakers, and further that the First Amendment does not allow prohibitions of speech based on the identity of the speaker. Corporations, as associations of individuals therefore, have free speech rights under the First Amendment. Because spending money is essential to disseminating speech, as established in Buckley v. Valeo, Limiting a corporation's ability to spend money is unconstitutional because it limits the ability of its members to associate effectively and to speak on political issues. The decision overruled Austin because that decision allowed different restrictions on speech-related spending based on corporate identity. Additionally, the decision said that Austin was based on an equality rationale, trying to equalize speech between different speakers, that the court had previously rejected as illegitimate under the First Amendment in Buckley. The Michigan statute at issue in Austin had distinguished between corporate and union spending, prohibiting the former while allowing the latter. The Austin court, over the dissent by Justices Scalia, Kennedy, and O'Connor, had held that such distinctions were within the legislature's prerogative. In Citizens United v. Federal Election Commission, however, the majority argued that the First Amendment purposefully keeps the government from interfering in the marketplace of ideas and rationing speech, and it is not up to the legislatures or the courts to create a sense of fairness by restricting speech. The majority also criticized Austin's reasoning that the distorting effect of large corporate expenditures constituted a risk of corruption or the appearance of corruption. Rather, the majority argued that the government had no place in determining whether large expenditures distorted an audience's perceptions, and that the type of corruption that might justify government controls on spending for speech had to relate to some form of quid pro quo transaction. There is no such thing as too much speech. The public has a right to have access to all information and to determine the reliability and importance of the information. Additionally, the majority did not believe that reliable evidence substantiated the risk of corruption or the appearance of corruption, and so this rationale did not satisfy strict scrutiny. The court's opinion relied heavily on the reasoning and principles of the landmark campaign finance case of Buckley and First National Bank of Boston v. Bellotti, in which the court struck down a broad prohibition against independent expenditures by corporations in ballot initiatives and referenda. Specifically, the court echoed Bellotti's rejection of categories based on a corporation's purpose. The majority argued that to grant freedom of the press protections to media corporations, but not others, presented a host of problems, and so all corporations should be equally protected from expenditure restrictions. The court found that BCRA 201 and 311, provisions requiring disclosure of the funder, were valid as applied to the movie advertisements and to the movie itself. The majority ruled for the disclosure of the sources of campaign contributions, saying that prompt disclosure of expenditures can provide shareholders and citizens with the information needed to hold corporations and elected officials accountable for their positions and supporters. Shareholders can determine whether their corporation's political speech advances the corporation's interest in making profits, and citizens can see whether elected officials are in the pocket of so-called moneyed interests. This transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages. Concurrences. Chief Justice Roberts, with whom Justice Alito joined, wrote separately to address the important principles of judicial restraint and stare decisis implicated in this case. Roberts wrote to further explain and defend the court's statement that there is a difference between judicial restraint and judicial abdication. Roberts explained why the court must sometimes overrule prior decisions. Had prior courts never gone against stare decisis, that is, against precedent, for example, segregation would be legal, minimum wage laws would be unconstitutional, and the government could wiretap ordinary criminal suspects without first obtaining warrants. Roberts' concurrence recited a plethora of case law in which the court had ruled against precedent. Ultimately, Roberts argued that stare decisis counsels deference to past mistakes, but provides no justification for making new ones. Justice Scalia joined the opinion of the court, and wrote a concurring opinion joined by Justice Alito in full and by Justice Thomas in part. Scalia addressed Justice Stevens' dissent, specifically with regard to the original understanding of the First Amendment. Scalia said Stevens' dissent was in splendid isolation from the text of the First Amendment. It never shows why the freedom of speech that was the right of Englishmen did not include the freedom to speak in association with other individuals, including association in the corporate form. He further considered the dissent's exploration of the framers' views about the role of corporations in society to be misleading, and even if valid, irrelevant to the text. Scalia principally argued that the First Amendment was written in terms of speech, not speakers, and that its text offers no foothold for excluding any category of speaker. Scalia argued that the Free Press Clause was originally intended to protect the distribution of written materials and did not only apply to the media specifically. This understanding supported the majority's contention that the Constitution does not allow the court to separate corporations into media and non-media categories. Justice Thomas wrote a separate opinion concurring in all but the upholding of the disclosure provisions. In order to protect the anonymity of contributors to organizations exercising free speech, Thomas would have struck down the reporting requirements of BCRA 201 and 311 as well, rather than allowing them to be challenged only on a case-specific basis. Thomas's primary argument was that anonymous free speech is protected and that making contributor lists public makes the contributors vulnerable to retaliation, citing instances of retaliation against contributors to both sides of a then recent California voter initiative. Thomas also expressed concern that such retaliation could extend to retaliation by elected officials. Thomas did not consider as-applied challenges to be sufficient to protect against the threat of retaliation. Dissent. A dissenting opinion by Justice Stevens was joined by Justice Ginsburg, Justice Breyer, and Justice Sotomayor. To emphasize his unhappiness with the majority, Stevens read part of his 90-page dissent from the bench. Stevens concurred in the court's decision to sustain BCRA's disclosure provisions but dissented from the principal holding of the court. He argued that the court's ruling threatens to undermine the integrity of elected institutions across the nation. The path it has taken to reach its outcome will, I fear, do damage to this institution. He added, a democracy cannot function effectively when its constituent members believe laws are being bought and sold. Stevens also argued that the court addressed a question not raised by the litigants when it found BCRA 203 to be facially unconstitutional, and that the majority changed the case to give themselves an opportunity to change the law. He argued that the majority had expanded the scope beyond the questions presented by the appellant and that therefore a sufficient record for judging the case did not exist. Stevens argued that at a minimum the court should have remanded the case for a fact-finding hearing, and that the majority did not consider other compilations of data, such as the congressional record for justifying BCRA 203. Stevens argued that the court had long recognized that to deny Congress the power to safeguard against the improper use of money to influence the result is to deny to the nation in a vital particular the power of self-protection. After recognizing that in Buckley v. Valeo the court had struck down portions of a broad prohibition of independent expenditures from any sources, Stevens argued that nevertheless Buckley recognized the legitimacy of prophylactic measures for limiting campaign spending and found the prevention of corruption to be a reasonable goal for legislation. Consequently, Stevens argued that Buckley left the door open for carefully tailored future regulation. Although the majority echoed many of the arguments in First National Bank of Boston v. Bellotti, Stevens argued that the majority opinion contradicted the reasoning of other campaign finance cases, in particular, Austin v. Michigan State Chamber of Commerce and McConnell v. Federal Election Commission, and found it telling that the majority, when citing such cases, referenced mainly dissenting opinions. Stevens argued that the majority failed to recognize the possibility for corruption outside strict quid pro quo exchanges. He referenced facts from a previous BCRA challenge to argue that, even if the exchange of votes for expenditures could not be shown, contributors gain favorable political access from such expenditures. The majority, however, had considered access to be insufficient justification for limiting speech rights. Stevens responded that in the past, even when striking down a ban on corporate independent expenditures, the court never suggested that such quid pro quo debts must take the form of outright vote buying or bribes. Bellotti. Buckley, he said, also acknowledged that large independent expenditures present the same dangers as quid pro quo arrangements, although Buckley struck down limits on such independent expenditures. Using the record from a previous BCRA 203 challenge, he argued that independent expenditures were sometimes a factor in gaining political access and concluded that large independent expenditures generate more influence than direct campaign contributions. Furthermore, Stevens argued that corporations could threaten representatives and senators with negative advertising to gain unprecedented leverage. Stevens supported his argument by citing Caperton v. Massey Coal Co., where the court held that $3 million in independent expenditures in a judicial race raised sufficient questions about a judge's impartiality to require the judge to recuse himself in a future case involving the spender. Stevens argued that it was contradictory for the majority to ignore the same risks in legislative and executive elections, and argued that the majority opinion would exacerbate the problem presented in Caperton because of the number of states with judicial elections and increased spending in judicial races. Second, Stevens argued that the majority did not place enough emphasis on the need to prevent the appearance of corruption in elections. Earlier cases, including Buckley and Bellotti, recognized the importance of public confidence in democracy. Stevens cited recent data indicating that 80% of the public view corporate independent expenditures as a method used to gain unfair legislative access. Stevens predicted that if the public believes that corporations dominate elections, disaffected voters will stop participating. Third, Stevens argued that the majority's decision failed to recognize the dangers of the corporate form. Austin held that the prevention of corruption, including the distorting influence of a dominant funding source, was a sufficient reason for regulating corporate independent expenditures. In defending Austin, Stevens argued that the unique qualities of corporations and other artificial legal entities made them dangerous to democratic elections. These legal entities, he argued, have perpetual life, the ability to amass large sums of money, limited liability, no ability to vote, no morality, no purpose outside profit-making, and no loyalty. Therefore, he argued, the courts should permit legislatures to regulate corporate participation in the political process. Legal entities, Stevens wrote, are not we the people for whom our Constitution was established. Therefore, he argued, they should not be given speech protections under the First Amendment. The First Amendment, he argued, protects individual self-expression, self-realization and the communication of ideas. Corporate spending is the furthest from the core of political expression protected by the Constitution, he argued, citing Federal Election Commission v. Beaumont, and corporate spending on politics should be viewed as a business transaction designed by the officers or the boards of directors for no purpose other than profit-making. Stevens called corporate spending more transactional than ideological. Stevens also pointed out that any member of a corporation may spend personal money on promoting a campaign because BCRA only prohibited the use of general treasury money. Fourth, Stevens attacked the majority's central argument, that the prohibition of spending guards free speech and allows the general public to receive all available information. Relying on Austin, Stevens argued that corporations unfairly influence the electoral process with vast sums of money that few individuals can match, which distorts the public debate. Because a typical voter can only absorb so much information during a relevant election period, Stevens described unfair corporate influence as the potential to outspend others, to push others out of prime broadcasting spots and to dominate the marketplace of ideas. This process, he argued, puts disproportionate focus on this speech and gives the impression of widespread support regardless of actual support. Thus, this process marginalizes the speech of other individuals and groups. Stevens referred to the majority's argument that there is no such thing as too much speech as facile and a straw man argument. He called it an incorrect statement of First Amendment law because the court recognizes numerous exceptions to free speech, such as fighting words, obscenity restrictions, time, place, and manner restrictions, etc. Throughout his dissent, Stevens said that the majority's slogan ignored the possibility that too much speech from one source could drown out other points of view. Fifth, Stevens criticized the majority's fear that the government could use BCRA 203 to censor the media. The focus placed on this hypothetical fear made no sense to him because it did not relate to the facts of this case. If the government actually attempted to apply BCRA 203 to the media, and assuming that Citizens United could not constitute media, the court could deal with the problem at that time. Stevens described the majority's supposed protection of the media as nothing more than posturing. According to him, it was the majority's new rule, announced in this case, that prohibited a law from distinguishing between speakers or funding sources. This new rule would be the only reason why media corporations could not be exempted from BCRA 203. In this, Stevens and the majority conceptualize the First Amendment's protection of the press quite differently. Stevens argues that the press is an entity, which can be distinguished from other persons and entities which are not press. The majority opinion viewed freedom of the press as an activity, applicable to all citizens or groups of citizens seeking to publish views. Sixth, Stevens claimed that the majority failed to give proper deference to the legislature. Stevens predicted that this ruling would restrict the ability of the states to experiment with different methods for decreasing corruption in elections. According to Stevens, this ruling virtually ended those efforts, declaring by fiat that people will not lose faith in our democracy. Stevens argued that the majority's view of a self-serving legislature, passing campaign spending laws to gain an advantage in retaining a seat, coupled with strict scrutiny of laws, would make it difficult for any campaign finance regulation to be upheld in future cases. Seventh, Stevens argued that the majority opinion ignored the rights of shareholders. A series of cases protects individuals from legally compelled payment of union dues to support political speech. Please subscribe and thanks for watching.